Because there is wike who is omnipotent, omnipowerful, omnipresent. If there is wike who is now the demigod, or maybe we should be going to church on Sundays to worship wike, put his picture in the sanctuary and begin to worship wike in River State as God of River State. If that is what wike has assumed himself to be, and he's getting backing of the Federal High Court, we are, as lawyers in defense of democracy, telling wike that he doesn't have such powers. Institutions of government, in a democratic government, institutions are very strong. There is what we call rule of law. Whether or not you think the rule of law is on paper, it cannot be implemented, or rule of law can be bent when it has to do with prominent, big politician or somebody that have now assumed himself to be God, and because of him, rule of law will be turned upside down. We are saying that this democracy will sustain it together in this country. No matter what anybody thinks he is, no matter how many million, how many billion you get, we don't have such. We have our constitutional right within the ambits of the law, within Section 39, to freely express dismay, displeasure against corruption, against injustice, against oppression. We have our right under Section 40 to gather as we have gathered now as coalition of...
President Bola Ahmed Tinubu and the APC keep quiet, thinking it is for their political benefit now. So all the rat can continue, all the road can continue. But when this serpent turns into a dragon tomorrow, they should not complain, no, because assuredly it will go round. In conclusion, we stand united in our call for accountability within our judicial system. The integrity of our court must be preserved if we are to maintain faith in democracy itself, and reiterate our call for immediate action against these biased judges of the Federal High Court in Abuja. We all just stakeholders in Nigeria legal system to join us in safeguarding our democracy and act swiftly, decide to sustain it together in this country. No matter what anybody thinks he is, no matter how many million, how many billion you get, we don't have such. We have our constitutional right within the ambits of the law, within Section 39, to freely express dismay, displeasure against corruption, against injustice, against oppression. We have our right under Section 40 to gather as we have gathered now as coalition of organizations in defense of the truth and in defense of democracy in River State. That remains the law, and we are telling the Chief Judge of the Federal High Court that he cannot turn the Federal High Court to a mere agency of Nyesom Wike. Maybe we should now rename the Federal High Court to Nyesom Wike Federal High Court. If that is what Honorable Justice Johnson wants Nigerians to believe, from today, maybe we'll begin to call the Federal High Court Nyesom Wike Federal High Court. And we are saying that lawyers in defense of democracy will continue to speak the truth, will continue to defend democracy, we must continue to defend the rule of law within the ambits of the law. Thank you so much. Members of the opposition, these are the issue of double standard. The problem, if you in a system that promote equality and respect for the representation of all human person and association, we must be able to have one governing principles in our law that protect all and does not discriminate against another. In just 10 days, the same judge reached conflicting decisions on the same issue to achieve a pro-Wike interest, or is it that there is a different rule of court to decide the case of the APC matters and a different rule for other parties? Other political parties as established in Section 221 to Section 229 in the Constitution of the Federal Republic of Nigeria enjoy equal rights, equal representation, equal authority under the law. And any attempt to discriminate, to differentiate, and to reduce that separation will not be welcomed by members of the opposition. To Justice Lifu, the agenda is one, but the reasoning and conclusion may be different and even conflicting. Such inconsistency poorly reflects his judgment and raise questions about the impartiality and commitment to fair legal practices in Nigeria. Justice Lifu, in his judgment of 30th September, also purported to have directed the Independent National Electoral Commission, INEC, not to release voter register to River State Independent Electoral Commission for the conduct of local government elections. We wonder why we, even as chairmen of political parties in Nigeria, have received most of the members of the coalition who are participating in the election, PRP, APP, have received the registered voter from INEC, which the drive is with us. The drive is with them. They have presented it to the public in Rivers State, and as a member of this, the members of this coalition, they have acknowledged the receipt from INEC. The Federal High Court by Justice Lifu wants to take us back by asking INEC not to release the voter register. How do you say they should not release the voter register that has been released? The voter register is already in the custody of political parties that are participating for the local government elections. APP had confirmed that in one of their rally. PRP confirmed that they have the same voter register in their custody. So, in their custody. In light of this severe concern regarding judicial conduct, JAD will take further steps by writing petition to international bodies, including the United States, the United Kingdom, and European Union countries. We will advocate for visa ban against these politically biased judges and call for their names to be placed on international alert list. We must hold accountable those who compromise our democracy through their actions on the bench. In our petition, we will urge these countries to investigate the lifestyles of these judges and their family members abroad, especially their spending and investment in property, jewelry, and stocks. Given this, Judge Totu continue assignment of cases related to Rivers State cannot be justified. It is essential for the credibility of our judiciary that all judges operate without any semblance of partisanship or favoritism. Now we understand why so many people spoke against Justice Totu's appointment as the federal chief judge of the High Court. If only we had listened to these voices these days, maybe the country would have been saved from this embarrassment coming from the Federal High Court today. Nigeria will recall that sometimes last year, following his anti-party activity and calls to the PDP to take disciplinary action, Wike went to court and obtained an ex parte order to restrain the PDP from expelling him from the party. That was the end of that matter till today. Ex parte orders are now used to serve as final judgment in the case of the court matter. In January 2023, the then state chairman of closer to the grassroots to our people. What we are fighting for is multi-party democratic participation. The right to participation is fundamental in our constitution. The right to free and fair processes for election is also fundamental in our constitution. What we are struggling for is that federal agencies should not take over what belongs to the state. We are running a federating unit, a federation that has its own federating separations, that has all the rules and regulations on how we deal with ourselves. And we will further weaken the state if we want federal agencies like the Federal High Court led by John Toso to continue to take decisions, and judges under the Federal High Court taking decisions that undermines our democratic development, our democratic projection. The 5th of October is the key point here. The Rivers State Independent Electoral Commission, what Nigerians should know, that's why I used to tell a lot of Nigerians, what Nigerians should know, in independent elections in the state, they are not under in their National Independent Electoral Commission. They are a creation of the constitution of their own. They derive their power from the constitution. They share equal authority as INEC shares its own authority in the constitution, and they have the authority to be able to carry out their functions without any hindrance, any manipulations, or any intimidation from any quarters. What we are saying is that in defense of to save this democracy, we have come together from civil society groups, from political parties leaders, from ethnic nationalities, from lawyers in defense of democracy. We have come together to state this categorically, that Justice IBC Igwe judgment in High Court, Rivers State High Court, has clearly stated that the elections will go on Saturday. And what we were urging is that these elections should go on unhindered, and these elections should go on without any sense of violence. Those who want to participate in the election should participate. If you have any other issue, you take it to the tribunal as it's set up. We must fight continuously to make sure the temple of justice remains the temple of justice. Even in the worst period where our democracy was not there, every arm will be stopped by those who have hijacked our democracy, but the judicial system was never touched. Because the judiciary remained the last hope of the common man, where people can go and get justice. Local government election is a process by which people are going to get elected into office. We are not there yet. We are working on a lot of other things to make sure that government become a true representation of the people. But we cannot get there if we do not defend the right of those whose rights have been oppressed today, if we do not stand and speak on behalf of political party, if you listen to Martin Muller when he talked about when they come today and you are not standing, it might be your turn tomorrow. So for us to save this democracy, courageous men, determined people who are determined to make Nigeria work for our citizens, for our masses, must stand up in defense of this democracy. This democracy, we have invested our energy. People have died because of it. People are standing and losing their business and sacrificing to run elections and run presidential elections. And we must defend it to wait and see that this democracy is sustained and the history is left to be told by our unborn children. 5th October, we must state categorically that the judgment that was delivered by Justice Lifuya is actually, for me, is belated. Because one thing that is there is that there's a judgment already from a federal high court in Rivers State, state high court in Rivers State, and that judgment has already clearly stated that the election will go on. And that judgment stopping that the voter register should not be given to political parties. Yeah. Political parties severally, more than 4 APP have said it, PRP have said it, another party, coaliting parties who are part of our coalition, who are participating, are clearly stated they already have the voter register before that day, a week ago. About 2 weeks now, they have the voter register. So the voter register is already on ground that they will use to conduct the election. And the independence of State Independent Electoral Commission should not be compromised at any time. And because whatever we start in little way can offend the whole body of our elections. Because if you take police to go and block Rivers State Independent Electoral Commission, one day the federal government will come and say they are blocking the National Independent Electoral Commission. Because we must defend in little ways before we'll be able to defend our collective interest. Our interest is for justice to be served in the way that the law has stipulated it. It's for people's right to be respected. Our interest is also to tell you that Section 109, Section 1G, it clearly states that if you have decamped from the seat where you are elected, you will vacate your seat. It's not something we have to wait for people to give any effect to, because nobody to even give effect to that provision of the law, because even the person that is supposed to at the camp and a new speaker is already there who have given all the necessary input to that case. So what we are saying today is that the election on the 5th of October is an election slated already in process. And we must save our democracy by allowing that election to come in place so that we will continue to build on our interest. It's multi-party democratic system in this country. If we allow people to suppress the views of the Nigerian people, to suppress to a point when we run into a situation of a one-party state, we all have ourselves to blame. As our interest is that every political party, the international committee, they must look at this, because political parties are critical vehicle for the establishment of good governance in the country. And especially opposition political parties are very important to make sure that democracy works for our people. Because if we avoid this process and we do not allow the check and balances that exist currently to continue to exist and even flourish and grow to a point that political party can have the right and the authority to hold government accountable to their promises, then we have failed as a people. So in lieu of that, and the refusal for us not to fail, is why people with conscience, people who are determined to safeguard this, who are at the cost of their life, are saying that the Saturday elections is an election already in process. It's an election already in process. And because it's in process, a judge, Igwe of the State High Court in Rivers State, has given power and authority to that election. We want that election to go peacefully. Let people go and exercise their rights. And everywhere the local government election is happening in Nigeria, let people go and exercise their rights and let people participate. The other issue bordering on this, we will continue to speak on it and make sure that we have a determination, a system that is just, that is fair, that is equitable, and that respects the rule of law and respects constitutionalism in our democracy.